Please be seated. We have only one case remaining on the calendar this morning, and that's Iman versus City of West Palm Beach. We'll hear from the appellant.
Thank you, Your Honor. May it please the Court, my name is Bill McCabe. I represent the claimant, Mr. Iman. I'd like to reserve 2 minutes for rebuttal. In this case, the Judge of Compensation Claims found that the employer carrier presented clear and convincing evidence sufficient to rebut the statutory presumption of compensability afforded a law enforcement officer by FS 112.181. And as such, the JCC found that the claimant's heart disease and myocardial infarction was not compensable. We submit there's no competent evidence to support this conclusion. In this case, the claimant was a police officer. On July 10, 2002, he suffered a heart attack or myocardial infarction. He was discovered to have had coronary artery disease. Now, 112.18 is the statute that affords a police officer who suffers a disability as a result of a cardiac condition and other conditions, but cardiac is the one in this situation, or heart disease, I should say, a presumption that the heart disease is compensable unless the contrary be shown by competent evidence, is what the statute says. Now, this claimant met all the criteria to be afforded the statutory presumption. In fact, it was stipulated by the employer carrier that he did. He was a police officer. He had a pre-employment physical in 1981 that showed no evidence of any heart disease of any nature or kind, including no high cholesterol. He had a myocardial infarction on July 10, 2002, and it rendered him disabled. He didn't go back to work until September 9, 2002. The Florida Supreme Court in Caldwell versus Division of Retirement, which I think is a case that applies to this case, 372 Southern 2nd 438, stated that in order to rebut the statutory presumption, it is necessary to show that the disease causing disability was caused by a specific non-work-related event or exposure. This Honorable Court said the same thing in Daniels versus Division of Retirement, 389 Southern 2nd 340. Now, in this case, the judge found that the presumption was rebutted by the testimony of a Dr. Vadir, who was one of the treating cardiologists. He opined that the major contributing cause of the claimant's myocardial infarction was the coronary artery disease, probably precipitated by stress, which caused the arteries to close. He further opined that the major contributing cause of the coronary artery disease was high cholesterol, which he stated was unrelated to the claimant's employment as a police officer, but rather related to his diet and family history. Now, we submit that this does not constitute competent evidence to overcome the presumption. First, we contend that a long-standing history of high cholesterol is not a specific non-work-related event or exposure as contemplated by Caldwell versus Division of Retirement. It's simply one of many risk factors for coronary artery disease. That's all it is. There's other risk factors for coronary artery disease also, which is, for example, smoking, hypertension, diabetes, hereditary, and stress. Coronary artery disease is a multifactorial disease. We submit that a risk factor is not a specific non-work-related event or exposure. A specific non-work-related event or exposure would be something like a blow to the chest or exposure to some chemical outside of work or smoke or possibly a congenital, there's one case involving a congenital heart condition that the claimant had since birth.
Well, Mr. McCabe, is high cholesterol a physical problem?
Well, high cholesterol is a physical problem in that it is one of the risks for coronary artery disease. But in and of itself, high cholesterol, a lot of people have high cholesterol. Take medication for it, exercise for it.
They do those things because it's a physical problem, right?
Well, it's a risk factor that could contribute to coronary artery disease just like these other risk factors could. But that's the whole purpose of the statutory presumption, is so somebody doesn't have to try to figure out what risk factor contributed most to the coronary artery disease, et cetera. It's presumed that it's the stress associated with the employment. And I might add that the statute is to be interpreted in a manner to enforce, if you will, the beneficial purpose of the statute.
Let me talk about the stress issue for a minute. You raised in your brief, I think, the fact that you ought to consider the stress of the job aggravated the condition, even if you accept that high cholesterol is some kind of condition and underlying disease. That stress on the job created or brought on the heart problem. Therefore, it ought to be compensable. I think their response is that argument was not raised below.
Well, that's kind of the third argument I've raised, but I think that actually ties in with my second argument too, and that is that if this court considers high cholesterol to be a specific non-work related event or exposure, then Dr. Vadier's testimony still does not constitute the sufficient level of proof necessary to overcome the presumption. And the reason for that is because, again, the Caldwell case says that if there is balanced proof, one doctor saying it's not work-related, one doctor saying it's work-related, then the only way the carrier can overcome the presumption under those circumstances is by clear and convincing evidence or cogent proof to the contrary. If there's a balance of proof, the presumption prevails. That's exactly what happened in the Caldwell case. Now, this Dr. Vadier's opinion does not rise to the clear and convincing standard, which is a very high standard. And I'll cite the part of the record that I think kind of nails it as far as whether his testimony is clear and convincing or not is page 250 and 251 of the record. And the question is, now with respect to the risk factors that you just mentioned, would you agree that some of these risk factors are stronger than other risk factors in terms of the onset of cardiac heart disease? Answer, again, it's a multifactual disease. Whether they're stronger, I cannot answer that question because they're all put together. Next question. Let me phrase it this way. Isn't it fair to state that we have stronger risk factors and weaker risk factors, and because we have these risk factors that have different weight, we can't state with medical certainty what exactly the cause was for the onset of the cardiac heart disease? Answer, correct. It's a multifactual disease. It's hard to pinpoint which one caused this, this, and this. Question. So it could have been stress. Answer. It could be stress. It could be high cholesterol. It could be, the hypertension. It could be, there's a whole lot of reasons, and it's a multifactual disease. Now, does that sound like clear and convincing evidence that the cause of this coronary artery disease was high cholesterol? Absolutely not. Now, there's other parts in his record where he says he thinks it is, but that's his testimony on page 250, 251 of the record. Also, the family history says the high cholesterol is from family history. There's no family history. There's no medical records of any family history in here that this man's family had any high cholesterol. At best, there's testimony that he had one uncle that had bypass surgery when he was in his 60s, one when he was in his 70s, but nobody knows why they had the bypass surgery. They don't know whether it was because of high cholesterol. The other reason he gives is the diet. Well, this man's diet, bad diet that he had, was because he was a police officer. He worked the night shift for many years, said there weren't that many good places to eat. Policemen go in, grab meals when they can. He never even had any evidence of high cholesterol until 1985, which is 4 years after he started working as a police officer. His pre-employment physical and two physicals after that were in the record, 82 and 84, there was no evidence of any high cholesterol, even in those physicals. Also, and this is kind of a long way getting back to your question about the stress aggravated the myocardial infarction. Both doctors definitely said that stress was a precipitating factor of the myocardial infarction. Dr. Vidir, in fact, stress could conceivably even contribute to high cholesterol. When Dr. Vidir was asked that question on page 243 and 244 of the record, there's a question, is there any connection between stress and elevated cholesterol? He says, you know, I can't answer the question definitively, but what most of us study, if you go to literature at least, how my knowledge goes, stress rapidly accelerates the arteriosclerosis. It raises the blood pressure, etc. And then he goes on to say that one of the factors associated with having heart attacks is stress, and everybody knows that. That's what he says on page 244 of the record. The judge, in fact, even finds in his order that Dr. Vidir opined the major contributing cause of the claimant's myocardial infarction was a coronary artery disease, probably precipitated by stress, which caused the arteries to close. So we submit that there's just simply not evidence in this case to overcome a very strong statutory presumption of compensability.
Well, now, you use the example of a previous event, and I think the example you gave was getting struck in the chest or something, let's say, when you're away from work. But in Caldwell, the officer had arteriosclerosis. How is that different from someone who has, I guess they call it hyperlipidemia or whatever the term for high cholesterol is? In other words, it's an existing condition in the body, a medical condition, which is unrelated to work. And just as the high cholesterol was in this case, isn't it, how do you differentiate it from the arteriosclerosis in Caldwell?
Well, the Caldwell case, of course, the fact that there was arteriosclerosis, one doctor says it was from non-work-related arteriosclerosis, and one said it was from stress, and the Supreme Court said balance presumption applies, so that ties in with my second argument right there. But my first argument is because they don't really know what causes coronary artery disease. In fact, the other doctor, Dr. Ben-Simone, I believe was his name, says that if Dr. Vidir can tie it down to one factor, he deserves the Nobel Prize.
Well, if you don't know what causes coronary heart disease, then the presumption could never be overcome in any case under any set of facts.
Yes, it could, very easily, if somebody gets a blow to the chest and has a heart attack. Or somebody walks in, they're raking the leaves at their house and they light it on fire and they inhale all this smoke or something, and the next thing you know, they're down with a heart attack or something like that. I mean, that seems to be like a non-work-related event or exposure. The legislature certainly doesn't want somebody to get compensation if it's obvious that it was from one of these, some other event that occurred outside of the workplace. But otherwise...
What if you have congenital heart failure, which is caused by some genetic condition, completely unrelated to your work?
And even at that, the court stated in that City of Temple Terrace case that it could still be compensable if you could show that the work aggravated or accelerated even the pre-existing condition.
I come back to my original question. Where was that argument preserved here?
Well, the City of Temple Terrace case probably wasn't specifically made below.
Okay.
May it please the Court, my name is Michael Edwards. I represent the City of West Palm Beach and Johns Eastern. I would first like to thank the Court and Mr. McCabe for accommodating my vacation schedule. And my wife and children, thank you as well. This case presents a scenario that is, in my opinion, very unusual. It's not one that I have come across before. Most of the cases that I have dealt with in 112, 118 cases involve hypertension. And I've never had a case where there was a significant elevated cholesterol without it. And most of the cases that involve hypertension, the doctors classify it as essential hypertension, which means no known cause. And in those cases, the presumption clearly applies because you can't pinpoint a non-occupational cause.
Mr. Edwards,
Yes, sir.
wasn't this statute put in place to avoid litigating over this very kind of causation when the legislature said an event or exposure? What is the event or the exposure in this case?
The event or the language that the Caldwell case also refers to that as a specific hazard or non-occupational factor, but clearly it's the elevated cholesterol. And the thing that makes this case unusual is that the doctor was able to pinpoint over 13 years of severely elevated high cholesterol as the major factor that would have existed, in his opinion, Dr. Vadier's opinion, regardless of this man's occupation. The counsel referred to elevated cholesterol as one of the many risk factors. What's curious about the statute is that it refers to hypertension, heart disease, and tuberculosis. Well, hypertension is one of the risk factors for the development of heart disease, but yet it's one of the enumerated conditions as well. The legislature, when it enacted 112.18, as the Supreme Court stated in Caldwell, attempted to establish a social policy that said that with respect to firefighters and later police officers, we're going to allow an exception to the rule that stress is not a compensable accident. And here they said that we're going to recognize that there's a special exception when it comes to this class of worker. They did not elevate stress alone to a compensable cause. They simply said that when you can't pinpoint a specific non-work related cause, we're going to presume that it's work related. And Judge Padovano, I agree with you. I think if we accept the claimant's argument in this case, it renders meaningless the provision that allows the carrier to rebut the presumption by showing a specific non-work related cause. I can't imagine a situation where a doctor would say stress was not a factor when it comes to these employees.
It said that in Caldwell.
Exactly. And the thing that I think is important here is that there was clear and convincing evidence in the testimony of Dr. Vadier of a specific non-occupational factor. The Bailey versus Temple Terrace case refers to the aggravation, which again wasn't raised below, but to address it, Bailey was, I think, decided in '88. It was prior to the legislature enacting the major contributing cause standard. And there by way of dicta said that, well, you can have a congenital condition, but the employee can still show an aggravation. Well, here we're not really dealing with aggravation here. The doctor said that stress on that particular day, a particular appearance in court, was a precipitation, and there is a difference. It used to be, prior to the major contributing cause standard, the standard questions to doctors were, did the accident at work aggravate, accelerate, or precipitate the condition? The typical scenario being a pre-existing asymptomatic herniated disc, for example. And in that prior to the major contributing cause standard, it could be the straw that broke the camel's back, and the carrier was on the hook for the whole amount. Now we're dealing with a different burden of proof, and it's not enough alone to say, well, it was a precipitating factor, it was a 1% factor, or whatever. Here, there was clear and convincing evidence that stood out, and the judge, by the way, didn't seem to buy the claimant's assertion that he was unaware of having had this condition for a period of 13 years, that it didn't seem plausible that no one would have ever made him aware of it. When the legislature went to establish the social policy, they didn't say, well, what they referred to was the stress associated with this type of job. They didn't refer to diet. They didn't refer to eating habits, and I don't believe that it was ever intended that the social policy be extended that far. Addressing counsel's reference to a portion of Dr. Badir's testimony where he goes into the multiple risk factors, my reading of that particular section, the questioning attorney quickly shifted to a generic, and I believe the doctor was answering in generic terms, but he never wavered from his belief that this man's long-standing, uncontrolled high cholesterol was the major contributing cause of the coronary artery disease, which was the major contributing cause of the heart attack on that day. Unless the panel has any questions, that's all I have. Thank you.
Just quickly, as far as the judge did disregard or disbelieve claimant's testimony that no one ever told him he had high cholesterol. She said he would have done, tried to curb his diet if he knew, but it was interesting that in the medical report when he was admitted to the hospital, which is at page 359, and a history, it goes cholesterol level unknown. So, I mean, that's what it was reporting when he went to the hospital. The Florida Supreme Court case does state in one part of the opinion, it says the statutory presumption can be rebutted by showing some other specific hazard or non-occupational factor was the cause of the disease, but then it goes on to state very clearly on page 441, to rebut the statutory presumption, it is necessary that the commission that they were dealing with at the time show that the disease causing disability or death was caused by a specific non-work related event or exposure. It's the very language this court used in the Daniels versus Division of Retirement case. We'd submit that if high cholesterol is considered a non-specific, non-work related event or exposure, that would severely erode the statutory presumption intended by the legislature. It would not be interpreting the statute in a manner consistent with the beneficial purposes intended, which is how this court indicated that it should be interpreted in City of Clearwater versus Carpentieri, which is also cited in the briefs. And as far as the social policy about a diet, evidence in this record, quite frankly, is that his bad diet was because of his job. And I think it's kind of common knowledge, really, that it's all sort of part of a, stress, eat and run type of position.
They're like donuts, right?
That's right. But
that's the stereotype.
We don't want to discourage that because Krispy Kreme needs all the help it can get right now.
Very true.
Fortunately, there's nobody else in there but you guys.
Really?
Thank you very much,
Your Honor.
Counsel. That concludes our arguments for the morning. We'll be in recess.